Okay.
Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I am your host, Marianne Petrie. This episode of Slam the Gavel is sponsored by CPS Protect Consulting Services. Child Protective Services cases are among the most frightening experiences any parent can endure. Don't face them alone. With Urgent Assist by CPS Protect, you get the peace of mind to raise your children as you see fit and the personalized assistance of their team of expert child welfare consultants, former CPS investigators themselves, right when you need it. Get started absolutely free at cpsprotect.com/register, and this is available in all 50 states. I have another announcement. Go to the site, pleasedoyourjob.com, and sign the petition. We need 2,000 more signatures to get a very important case reopened. That's pleasedoyourjob.com. I have a brand new guest. I'm so happy to have divorce attorney and author Ron Bavero on. We're going to talk about his new book, An Elephant Doesn't Marry a Giraffe, Everything I Learned as a Divorce Attorney. And he's going to share his experience as a divorce attorney and highlights practical tips for students interested in practice of family law. So I welcome you, Attorney Bavero. How are you this morning? And how did you get into being a divorce attorney?
Yeah. I'm great. Thank you for having me. It's really a pleasure to spend this morning with you. My entry into the field of family law came as a result of the fact that the person I was working with in the district attorney's office, I was an ADA in Westchester County first, became a family court judge and asked me to go with him as his law secretary. And so that was the opportunity to learn this critically important area of law and to get a taste of what it was like to be involved in the determination of those kinds of cases. And I did that for a number of years with Judge Fussell, and then moved over to the practice of family law in the context of basically doing mostly divorce work, but my work in that field was much broader because it encompassed areas like custody, adoption, all of those family orders of protection, all of those areas of law under the umbrella of family law.
Right, because there's a lot under that umbrella. These orders of protection, have you found that people weaponize those all the time?
It
Had you noticed that?
it is certainly an area that is ripe for abuse in the hands of someone who's, bent on basically destroying the other parent or the other spouse. And it's extremely difficult when you're viewing it from the context of the bench of
Mhm.
the judge adjudicating these cases, because very often it is very much one side saying one thing, one side saying the opposite, and it is challenging to discern the truth in that context. But being aware of the kind of global aspect of it, meaning that it comes up frequently in many of the cases, gives you the ability to kind of fine tune your 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 ability to discern where the truth is.
I'm sure it must be hard even to be a divorce attorney. You get cases, and I think you would hope people are telling you the truth?
Yeah, well, that's that's your hope,
Yeah.
but it's not always a realization.
Mhm.
Most people who come to the office, you get a sense of who they are in the initial consultation. And, I think that in that consultation, you'll get a sense of whether the person is there to, you know, address a serious issue or problem, or whether they're there for, purposes of making the other side, you know, feel oppressed in the case.
Mhm. You know, and did you probably, I'm sure you incorporated all of this into your book, and, how long did it take you to write this book with everything?
The book was written over a 2.5 year period.
Wow, okay.
And the reason for that is that in the first reiteration of the book, um, I basically focused on my experiences as a divorce attorney and relating in the book the various cases that I had been involved in. Of course, keeping confidential the names and identities of all the parties,
Mhm,
but it was very much a book about the life of a divorce attorney and the cases that you follow. But I then moved from that first writing to a transition where I took the stories from the book, but used them as an opportunity to talk to people
mhm,
about what they really need to know as they approach this process, how to avoid the critical mistakes. And so my book became a primer for people who didn't know where to start, for example,
mhm,
in the process of divorce. And I touch upon all of the key areas from beginning to end: when to consult with a divorce attorney, how to select the best divorce attorney for your case, how to uh, deal with the issue of attorney's fees. How do you pay for these expenses? And what are the things that you need to know? And then as you move through the rest of the book, we talk about all of the other elements of a divorce or separation case in terms of division of assets and support and all of those areas, and custody, of course.
what do you think of mediation? I don't know if, you know, if some people say, "No, mediation's bad." What do you think?
Well, I think that mediation is most successful when you have the type of case where both parties are truly interested in reaching a settlement.
Mhm,
Certainly, mediation is not appropriate when there's an imbalance between the two parties in terms of their ability to negotiate on their own behalf, or perhaps there's even some background in domestic violence there. Those are not appropriate cases for mediation. But
mhm.
cases where parties are committed to resolving a matter, mediation can be very effective, um, especially when you do it with a skilled mediator.
Mhm. And the cases that you had with domestic violence, some of them I'm sure were very bad. Did you find the judges were not looking at evidence?
I must say, in most instances, I was very fortunate to have really good judges in the area that I practiced. And so, you know, I ended up, because of my background in criminal law and being aware of criminal law and its impact in the area of domestic violence, I ended up um, working with the Pace Women's Justice Center,
Mhm,
which, as a, I would call it, unofficial advisor in the early years, to help people, to help guide the attorneys who were working in the Pace Women's Justice Center to effectively present cases of domestic violence, to obtain orders of protection and the necessary conditions that were part of it.
mhm,
So I feel like in my practice, I did make sure when I was meeting with people to explore this area, particularly in the consultation. And there's even a process that you have to go through. I mean, if someone comes in, you don't say to them, "Are you a victim of domestic violence?" Because you know the answer is usually no to that.
mhm,
But people, when they are brought along and asked, more relevant questions, frequently find the ability to discuss with the attorney what's really going on in their marriage and
mhm,
how there is an imbalance in power in the relationship.
hmm. And when it comes to custody, a lot of people, they want 50-50, unless there's, like, a child abuse issue, of course. And everyone wants to start off with 50-50. And what do you think about that?
I think that in some instances, it will work well, but
Mhm.
it's not for all cases. I
Right.
mean, the unfortunate part, I've seen some cases where the parties have 50-50 in terms of both the time spent with each party and the decision-making process. They're equal in terms of decision making. And yet the drop off and pickup were at the police station, you know.
Mhm.
So
Mhm.
that's not a case, that's appropriate for, split custody, or shared custody. So it can work well. It really requires parents to keep the children as their primary focus, being willing to compromise, being willing to alter the arrangement as necessity requires, and not make it just a hard and fast, this is my night, come, hell or high water. This is what we're doing. It requires those two people to effectively work post the divorce, in the interest of the children. And that's a very difficult and sometimes rare commodity in this, field.
Have you also found that you may have a client, but the opposing side, they've got a personality disorder that is continuously dragging you and your client back in for frivolous
Yes.
motions? Uh,
Yeah.
this
I
is,
mean, and those cases are more common than you realize.
oh yes, I
That you think that we've, resolved the case or the court has determined the case, and things will now proceed on a better path post the judgment of divorce or separation. And it's frequently not the case,
mhm.
because the unhappy party, the party who feels aggrieved by the process, continues to make it a nightmare, makes it a nightmare for the ex spouse or partner, makes it a nightmare for the child, because these are my rights, and I'm going to make sure that I'm fully, protected, and also, um, you know, in a position where I can dictate what the terms are. Those cases go on for years and years and years, and they end up tragically hurting both parties and the children.
And what also happens is, in some cases, the one side, whoever gets to speak first, will call out, "Well, that person's, mentally ill, and they're alienating me from the kids. That's what's going on." And then the judge will just run with that. The whole case just goes with that, and then that other parent is like, "No, I'm not even doing that," and they're getting a psych eval, and the judge may not be happy with that psych eval, they'll order another psych eval, and this whole case gets dragged out, and it's really a big mess. It doesn't stop.
Right. I mean, one of the big problems, particularly in the area of custody, is that the time span from beginning the matter until final adjudication is often months and years. And one of the things that you see frequently is that in the initial instance, the court, receives some information,
Mhm,
usually from the most vociferous and strident person, acts upon that. And that initial order, which the judge reminds everybody is just an initial order, we're going to get to the bottom of all of this. That order stays in place for months and years.
mhm.
And it's a very huge problem. And one of the things that's come up recently in New York is that the courts, particularly the higher courts in New York, have been very, very mindful that custody and visitation determinations should be based upon sworn testimony, evidence, non-hearsay statements of the parties, and not simply argument by counsel or hearsay statements. And so the courts have frequently spoken about the fact that these hearings should be taking place within days or hours of when the application is filed, not months and years later. And that is something which you would think, here we are in 2024, we've had hundreds of years of jurisprudence, would be a very simple fact to understand, that you have to determine cases based upon the evidence. And yet we have judges making determinations on imperfect information or hearsay statements. And to make the matter worse, a court in New York recently came down and said it is important that the judge resolve this matter quickly and there be a full evidentiary hearing to determine such an important issue as custody or visitation. The Office of Court Administration in New York sent out a memo in the aftermath of this decision, which said, well, it doesn't really mean that you have to have a full-blown hearing. Specifically contrary to the decision of the court. And so, I mean, this is a very, very troubling incident. And when the parties went back, and when I think it was Legal Aid or one of the entities tried to get all of the memos sent out by the Office of Court Administration to see exactly and to document what they were advising the judges to do in these cases, the court said no, it wasn't required for OCA to come up with these memos because it was only their position. Judges are free to disregard it. Well, of course they are. But when they get a memo from the Office of Court Administration, and that's the same entity that can send them to, the upper end of the county on a reassignment, you're going to listen. So, I wish there was a better way in which to deal with this. But unfortunately, judges are not holding prompt evidentiary hearings on a matter which is critically important.
Oh, I agree with you. They're dragging them out. I've talked to a lot of parents in New York, and they're calling these courts money courts. And there is also problems with these AFCs, which is Attorney for Child, in case anyone doesn't know what that means. They are disregarding evidence, or they're being paid off. This is a huge problem in these areas. And there was one case that, the judge was allowing the mother to keep the child away from the father, and while the mother was living with an 8-count felon. So this father was trying, and the money he went through trying to get an attorney to do the right thing was futile.
Yes.
So, what do you do when these people just will move farther away out of their divorce radius that they were told not to move out of? You can't make these people behave.
No. And at the end of the day, I've seen many instances where people have been disenfranchised from their children as a result of a court order. And it's unbelievably difficult and expensive to counter this. So I don't have a real good answer to this problem because, as you said, you can't change people's behavior. However, if the courts were to hold prompt evidentiary hearings, which might require, the court system to hire many more judges to handle these cases. In a lot of the counties, you have only a handful sometimes handling these cases, where the docket could be 500-600 cases. So we really need, number one, the resources, have the judges available who can handle these matters. We also need to do this on a prompt basis, so that those situations where the court order takes on a life of its own, even though it was improper at the beginning, just stays in effect.
And it can stay in effect, and some of these judges will order gatekeepers on these parents and not let them file any motions. I'm running into parents with this problem as well.
Right.
I'm lucky that wasn't done to me, but I never wanted to really go into a family courtroom. I didn't know this stuff existed until it happens to you.
Right. Right. And there's a certain irony here, because you mentioned family court. Family court was originally created and designed so that everyone would have access to the family court, and you didn't necessarily need an attorney, to represent you in these proceedings. There are provisions for appointment of counsel in certain types of cases, but a lot of times you have pro se people, meaning people who are not represented by counsel,
Yeah.
handling the matter.
Mhm.
And so that's what it was designed to do, to allow people access. The problem with that is you have pro se on one side, but the other side has counsel and is at a tremendous strategical, position of strength in that circumstance, because the attorney knows the court rules, knows, frequently has appeared in front of the judge. So there is a real imbalance in how handling some of these cases are handled.
Now, some people are also telling me there's, collusion involved, where the opposing attorney is BFFs with the judge, and even their own attorney is torpedoing the case because they're friends with the judge, and all three of them are working together against one parent. It's just gotten out of hand, and I know we've talked before on the phone, but I feel family court should just be abolished and take it down to civil court, where if there is, if there are any accusations of, say, child abuse or whatever, that should be handled also in criminal court. Ho how this will turn into a big mess,
Right.
as well.
I I believe that there should be a forum specifically for these cases.
Mhm.
Um, if family court is eliminated, all that's going to do is move the site of the battle to other places. What you really need are dedicated, understanding, knowledgeable judges who are presiding over these matters.
Mhm.
And what I've seen in my history of working in this field, there are a lot of wonderful judges who I had the opportunity to appear in front of. There were other judges who I appeared in front of who had no background, no training in this particular field, no empathy for the people who were going through it, and frequently treated assignment to family court or to the matrimonial court in Supreme Court as if they had been just sent, to Dante's Inferno. You
Oh.
know, they didn't want to go, they didn't want to handle these cases, and they made it abundantly clear. And what I would like to see is some kind of methodology where judges can be trained, judges who have an interest in this field are appointed to do that, um, and give them the resources that they need to try these cases. So I don't think it's necessarily a matter of, labels. We should abolish family court or we should abolish Supreme Court. no, we need a forum, a family court forum that is composed of people who really can help and
Mhm.
not become a hindrance to the resolution of the case.
And what the parents I'm talking to, it seems like we're gonna have to clean house because a lot of these judges, are just not, ruling fairly. They're being bought off. I don't know what to say. I'm, like, at a loss for words. I'm trying to help these parents, and I don't know what to say to some of their cases or why the judge ruled that way. I mean, I had it figured out as to how my judge ruled because he was BFFs with the opposing attorney, so the case was totally ruined before I walked in there. They knew exactly what they were gonna do. And it
Yeah.
seems to me like there's more of this going on with more parents that I interview and attorneys that there's a lot of, bad actors out there.
And so the only thing I can suggest in that vein is people, as part of the process, need to be, as you are, vocal about instances where there are abuses taking place and instances where the judges have done a great job handling things. I mean,
Mhm,
when I was working with the judge who I had the wonderful opportunity to work with, we took all of this very seriously.
mhm,
Our background was criminal law.
mhm,
Now, the reason that that's important is because, given that background, to us, prompt hearings, evidence, you know, ruling fairly and independently was the bedrock of what we did.
mhm.
Those are the types of judges that we need. And so in your area, you need to be much more vocal about who should be sitting on these cases. Someone gets nominated for family court, what do you know about this
Right.
person? What is their background? And you need to really talk about this, you
Mhm.
know, as an informed citizen who may be deciding to vote for one of these people, as a family court judge or a Supreme Court judge. Um,
Right, because when I went to the voting booth, this was, like, I think a year and a half ago, they were voting for judges, and it's like, I don't know these people because 'cause I'm new to this area. So I started Googling them and trying to make a good decision. It's like, I don't know these people. I've never met them, and I don't know what they stand for.
right, right. Um, so we need to find a better way, if you will, to get the right people on the bench.
Mhm. And that's hard to do because they're getting you know, some of these lawyers are chipping in for their judge campaigns, and they're getting in, and then this is how this corruption, as everybody knows, just evolves, and favors are done. It's just a big mess.
But shining the light is important.
Mhm,
People like you, there's another woman who I've had the good fortune to come across, Amy Pollock. She does a lot of writing in this field as well. And she's constantly writing, educating, talking to people about um, abuses within the system. And it is shining the light.
mhm.
Eventually, judges have to realize that they're answerable to someone, and that someone has to be the people who are voting for them or getting them into office.
Right, I've always encouraged people to report the judge. If the judge it's not the ruling, it's how you were treated, like, if the judge is screaming at you, write to the judicial committee and let them know how the behaviors of the judge. And if more people would do this and put in complaints, we could get rid of some of these people. And people court watch. I'm sure you know about people court watching, and these judges are, so they will, if a pro se is talking, they'll just hit the button and mute the pro se. So I had to write a complaint about that. You can't be doing that. You have to rule fairly, but it's like the Wild West in there. Yeah. So I don't know. I mean, I just encourage parents to keep telling their stories and keep writing their complaints to the judges about the judges.
Yes.
Now, some cases, as we talked about, have been dragged on. And I remember saying to my one lawyer, I said, I don't like coming in here. As we were going into the courthouse, I said, I hate this place. I don't want to go in here. And she goes, oh, really? Because some people love it. I'm like,
Yeah.
so, you've probably seen so many personality disorders. And of course, we don't know what they are because, we just call them personality disorders. And they enjoy running that parent through the mill, the other parent through the mill.
Yeah, there's a lot of opportunity for abuse within the court system when someone puts their mind to it and has the resources to do it.
Mhm. It seems like
But the,
oh, go ahead.
no, I was going to say, but the more that we, as I said, shine the light on it, I mean, for years, we have paid homage at the altar of the forensic psychiatrists. You
Mm,
know, they would come in, they would be hardly cross-examined. The judge appointed them,
mhm,
obviously was, inclined toward them. And for years, this process continued to take effect. But it's now slowly changing, and
mhm,
change has happened where, forensics are not required in every case,
mhm,
are not being appointed in every case. There have to be grounds and a basis for it. And they are not allowed to make certain determinations. Like, for example, you know, to opine on which parent should have custody of the child, that's the function of the court. It's not within the province of the forensic to be giving that.
mhm,
They're there to provide information about the psychological health of the parties or something of that nature. But they're not there to tell the judge which way he or she should rule. And
mhm,
so changes have come apart, come down. And there has been a blue ribbon panel appointed by the governor in New York, to deal with some of the abuses of that. And so what I'm saying is the more that you shine the light on these types of concerns, the more progress we're going to make.
mhm. Now, don't know how many cases you had where a judge just wrote no contact orders for that parent and took the child away from, we'll say, the target parent, and then wrote no contact orders. What did you, what is the recourse for that?
The recourse for that is to file appeals to the
Yeah.
appellate court and to do it promptly
Mhm,
and to ask for preference in the hearing of the appeal. Because, to the extent that the trial judges have huge calendars, the appellate judges also do. But at some point, and it's current in the rules of New York, there's a preference that's supposed to be given to custody and visitation cases
mhm,
in terms of the determination and timeliness of the hearing. So to appeal, to make the applications for a preference, and to build your record
mhm,
that you need to have this addressed as quickly as possible. Um, it's very frustrating. It's frustrating for the people involved in the case. But guess what? It's frustrating for us as attorneys
mhm,
because we're trying everything that we can to help our clients get through this
mhm,
and to address improper orders. Um, so, you've got to be somewhat dogged in your approach to the case, but having the mindset that you want to push this as quickly as possible, it becomes important.
Right, because the longer it drags out, people are getting sick. They're getting, it makes them ill. And I've also you talk to parents where there's custodial interference. The judge will order the parent to see the child on X amount of days, and that parent won't comply. But then when you write your emergency petition to fix this, the judge doesn't hold the offending party in contempt. They don't do anything. There's no accountability.
Right.
I don't know how much of that you've seen in your, your time, but this is just this is rampant.
You know, as I, you're not wrong. You're not wrong in what you're saying. It is difficult, however, to get the court to move in a prompt, you know,
Yeah.
manner.
Yeah, it's just, there's just a lot of frustrated, angry people out there because, the judges aren't doing the right thing. And, I'm just so glad to have you on and to speak with you and talk about your book. And, can you tell us where can people find your book?
So the book is available on various sites. It's available on Amazon.
Mhm,
It's available on Barnes and Noble, Draft to Digital,
mhm.
Google Books, and I have a website. So
Okay.
my website is www.divorced, the word divorced with a D on the end of it, everafter.com. And so my website contains all of my blogs,
Mhm,
in which I continue to write about important areas in family law. And it has more information about the book. What's probably been the most gratifying thing um, is that you embark upon a project and you think that you've produced a good work, but you're not quite sure. You're
mm,
not quite sure whether it's going to be received, as well as you think it will. The book has gotten unbelievable, effusive 5-star reviews from everyone who's read it.
mhm.
And that's a broad section of the population because you've got parties who are involved in divorce cases, attorneys representing them, judges, psychologists, and mental health professionals. Everyone who has written a review has said this is a really valuable book and one which is easy to read, meaning that it explains things in a very uh, obvious kind of way so that it's something that you can understand easily,
Mhm.
um, and it's based upon the many of the practical stories that are contained within the book.
I think that's great. I think that's great. Well, how did you pick the title, "An Elephant Doesn't Marry a Giraffe"?
So that comes out of the fact that if you speak to any matrimonial lawyer, they'll understand the phrase. And what it's meant to convey is that frequently in our practice, we find that divorcing parents or divorcing parties are much more similar than they are dissimilar. We think of the phrase, uh, about opposites attract. Well, in the case of divorce law, it seems that many more people are more similar than you realize. And so when one attorney says your client is being unreasonable, your client is taking ridiculous positions, sometimes the retort is that's why an elephant doesn't marry a giraffe because your client is no trip through the woods either.
Mhm. Wow, that's this I just so enjoyed interviewing you. I'd like to have you back on sometime and, uh, maybe some people will have some questions for you that I can run past you if you'd like to come back on another podcast.
I'd be happy to. And anybody who wants to contact me can write to me through that website.
And I'll put that in the podcast notes as well. And is there any words of advice that you can think of for people that are contemplating divorce?
Yeah, I think that education, self-education, is one of the most important parts. And one of the things that I always found was that the people who came to my office came from one of two groups. There were the planners, the people who knew they wanted a divorce and were there to get information so they could set themselves up for the divorce in the best, most powerful way. And then we had the people who often said this came out of the blue for them. They didn't know or didn't understand that their partner was intent on divorce, and they didn't know where to start. And this book is very much written for the people who don't know where to start. How to select the best attorney for your case, when you should be talking to an attorney. I even go into the fact that when you speak to a matrimonial attorney, what you should be telling them and not be telling
Mm-hmm.
them. Because there are limits to the attorney-client privilege.
Mm-hmm.
So you have to be aware, so to speak, sometimes when you're talking to an attorney. And people, for example, in the field of custody don't realize that they may have a therapist and think that everything they tell their therapist is protected and confidential. And the answer is, in the context of a custody case, it's not. The therapist notes may be available. The therapist may be called as a witness. And it's a very troubling thing for people to find out,
Mm-hmm.
later than sooner.
But wouldn't that be a HIPAA violation? No?
No. And
Oh, no.
what when you look at the case law,
Mhm.
particularly the case law in the state of New York, when people are involved in a custody case, they're deemed to have put into controversy their physical and mental health, so that the judge has not only the opportunity, but the right to explore their physical and mental health.
Mhm.
They therefore are impliedly waiving the doctor-patient privilege when they vie for custody.
Mm.
And that's something that people don't necessarily know. And sometimes in my, consultations, I'll say to someone, by the way, are you seeing a therapist? Yes. Well, are you aware of the fact that if this becomes a custody case, you know, that therapist could possibly be called as a witness
Mm. Mhm.
if, for example, you've made certain statements or admissions in the context of your therapy?
That's very important.
It is very important. And by the way, I have a whole blog on this on my website.
Oh, that's excellent. Oh, I'm
You know,
so glad. Yeah.
and it also talks about, talking to your matrimonial attorney as well.
Mhm. Mhm. No, I appreciate you having the time to come on this podcast, and like I said, I'd like to have you come back on.
I'd be
Um,
happy to.
Great. Well, hey, don't jump off. Slam the Gavel is a podcast to help the public understand what really goes on in these family courtrooms. I'm your host, Marianne Petrie, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, Cry Out for Justice, Poems of Truth, and Raised by These Wolves, How Family and Federal Courts Are Failing Our Children. You can find me on Spotify, YouTube, Apple, iTunes, uh, iHeartRadio, other platforms I don't know about, and feel free to buy me a coffee to help keep this podcast going. And I thank you so much, Attorney Bavero. Thank you.
Thank you.
Okay, I stopped. Whoops. Wait.